Part of the problem that we run into is you can lose tenants by the entirety if your trust owns those assets. And that's because the courts have said, look, ownership by a trust, even if the two trustees are married, is not ownership by husband and wife or a married couple. And the reason for that is one of those trustees could be replaced at any moment. I can create a trust. I'm the grantor. I'm the one who's making the trust, and I can be the trustee. But I can also be the grantor and name someone else as the trustee. So if I'm the grantor along with my wife, she's the trustee, and I name my brother as the other trustee, guess what? That's not tenants by the entirety. So to own assets tenants by the entirety, you have to own it as a married couple outside of your trust, which is oftentimes why I counsel clients, if you have a trust, and we do a lot of trusts here. So if you have a trust, own your asset jointly, but make it pay on death to the trust. And we do that with a lot of property. We use Ladybird deeds, and we'll talk about that in another podcast. We'll use beneficiary designations at the banks or with financial firms to make assets payable to the trust upon death, so that if both spouses die in a common accident, it's paid in the trust, it bypasses probate, and we get the benefits of the trust, but we still get that tenants by the entirety while both spouses are alive.